In its unanimous decision, the Supreme Court ruled that a deputy speaker or any other member of the House presiding over the business of the House does not lose his or her right to vote while presiding. Such a speaker or member speaker can also be counted as part of the quorum for decision making in the House under Article 1041 of the 1992 Constitution. Consequently, upon this, the Apex Court struck down Order 1093 of the Standing Orders of Parliament, describing it as unconstitutional. The said order provides that a deputy speaker or any other member of Parliament presiding over the business of the House shall not retain his original vote while presiding. The judgment flows from an application for interpretation filed by Law Lecturer Justice Abdullahi following that 30th November 2021 controversial budget approval. He asked the court to declare that 1. Based on Articles 102 and 1041 of the 1992 Constitution, a speaker or any other person presiding over Parliament cannot be said to be part of the members present for the purposes of decision making, and that 2. The first and second deputy speakers, when presiding over Parliament, have the same authority as the Speaker of Parliament and can therefore not be counted as members present for the purposes of taking a decision in accordance with Article 1041 of the 1992 Constitution. He thus wanted the Supreme Court to declare that the decision taken on 30th November 2021 to approve government's 2022 budget amounts to a nullity and is of no effect. The 7-member Supreme Court, however, held that a member speaker is entitled to be counted for purposes of quorum for doing business and to vote in business of the House, even while presiding. The Attorney General and Minister for Justice, Godfrey Yeboah-Dame, said the interpretation placed on the provision was simple and straightforward.
It's quite simple and straightforward. I perceive the issues are very simple and straightforward because nowhere in the Constitution has any statement be made that whenever a deputy speaker presides, he loses his right to vote. And indeed, as I indicated in the submissions filed in court, all the circumstances under which a member of Parliament will lose his right to vote have actually been spelled out in Article 104 itself. And so it is really devoid of controversy. And it's also very important to know that in all jurisdictions around the world, whenever the Speaker of Parliament or a Deputy Speaker of Parliament is a member of Parliament, he always has the right to vote. In England, it's the same. In America, it's the same. In Australia, Canada, everywhere is the same. In Kenya, even in Africa, Kenya, South Africa is also the same. Whenever the Speaker of Parliament or Deputy Speaker of Parliament is an MP, he never loses the right to vote. The right to vote is actually linked to the right to represent his constituency. So are we saying that on account of the person being a deputy speaker, he loses the right to represent his people when a major issue of national importance has arisen? I think the reason by the Supreme Court clearly is sound, is in accord with the practice in other jurisdictions around the world, and also clearly borne out by the letter and spirit of relevant provisions of the Constitution.
And this applies to forming of quorum for business as well?
Yes, because indeed the Constitution was quite clear. Whenever it seeks to exclude a member presiding, it says so clearly. So you see that for the commencement of business, ordinary business in Parliament, it says with the exception of the person presiding. But such exception is not made in the case of forum for decision making. So when it comes to forum for decision making, the member presiding, if he's a member of Parliament, clearly will be included.
I mean, in terms of subsequent parliamentary business, I mean, as Minister for Justice, you expect that this will resolve the matter and avoid the scenes that we saw when the Deputy Speaker had attempted to vote previously?
Oh, yeah, definitely, yes. I mean, those scenes clearly were needless and were really inspired by mischief, because all those mischief makers should have known that the practice in other jurisdictions, whenever the person presiding is a member of Parliament, that person is not precluded from exercising his right to vote, exists. So I think those scenes of Parliament were really unwarranted, and we really hope that it will not be repeated again. The Supreme Court has brought clarity on the matter and should guide the nation going forward.
For the applicant, Justice Abdullahi, the Supreme Court's pronouncement on the matter can only have far-reaching consequences.
I'm not surprised because I'm a lawyer. I know that going to court, there are only two outcomes. It's not like a football game where there'll be a draw. there would either be a win or a lose. But in this case, I think there's actually no one lost, because I think the Constitution wins, the people of Ghana win, and this is the best decision that I think we should have had. It puts clarity on the law, despite the fact that some of the reliefs that I was seeking were not obtained. But there's a far-reaching decision that has been made by the Supreme Court today, to the extent of striking out portions of the standing orders, and this is very good for all of us. It puts clarity on the rules of Parliament, and indeed it makes all of us citizens. And I think I would probably use this opportunity to invite all of us to be participants in the democratic credentials of this country. We all have to play our roles to ensure that we get the best outcomes of our constitution. This is just one of the things that we'll be doing going forward to ensure that the difficult decisions in bringing the sort of cases to the Supreme Court for clarity to be put on some of the issues that borders on sometimes illegality are all put to the past. This is what we stand for, and this is what I'm willing to do as a citizen of this country to ensure that our children and indeed our grandchildren live a better life in this country.
The Supreme Court was composed of Justices Jones Doche as President, Nene Amegache, Professor Ashikote, Mariama Owusu, Lovelace Johnson, Clemens Honyenuga, and Yoni Kulendi. And still in the Supreme Court, the court unanimously dismissed an application by embattled Asin North Member of Parliament James Gyakye-Quayson to quash a decision of the Court of Appeal not to refer Article 94(2)(a) to the Supreme Court for interpretation. The 5-member panel also dismissed by a majority decision of 3-2 another application of James Gyakye-Quayson for a stay of appeal proceedings at the Appellate Court and for referral of Article 94(2)(a) of the 1992 Constitution to the Supreme Court for interpretation. Mr. Quayson went to the Court of Appeal in an attempt to overturn a High Court judgment nullifying his election as Asin North MP and consequently removing him as a Member of Parliament and ordering a rerun of the poll in the constituency. With this latest decision, James Gyakye-Quayson will go back to the Court of Appeal for continuation of his appeal hearings, except where his lawyers file for a review of the decision. This is indeed a decision with far-reaching consequences on Ghana's parliamentary democracy. While others are already hailing the pronouncement, some believe it is going to have dire consequences on Ghana's highly polarized parliament. Reporting from the Supreme Court here in Accra, I am Sixtus Dong Ulo for Citi News.